Hi everyone, Liam Bailey here from O'Brien Palmer, and this week we'll be going to talk about personal insolvency agreements. Our conversation today is not really intended to be a technical guide of all of the various legislations and requirements of a personal insolvency agreement. I will put a link below if you want to get some of that information about sections, acts, cases, and technical requirements. Today is supposed to be a general conversation about what a personal insolvency agreement is, what it's meant to achieve, and how we go about making them successful. A personal insolvency agreement is an agreement entered into between a debtor and their creditors that resolves their administration of their personal affairs in a way that allows the debtor to avoid bankruptcy whilst protecting the interests of creditors. The idea being that the debtor will put a proposal to their creditors which is equal to or better than what creditors can hope to receive in the event that they were made bankrupt. And in doing so, creditors would support that agreement to allow the debtor to avoid bankruptcy. There's a lot of good reasons for this. People's earning capacity is usually significantly decreased if they go bankrupt. There's also significant costs associated with the administration of a bankrupt estate, as well as significant delays in achieving the results for creditors. So all in all, bankruptcy can be a fairly inefficient way to administer the affairs of a debtor. In a personal insolvency agreement, the debtor comes forward. They appoint what is called a controlling trustee. The controlling trustee takes control of all of the debtor's assets and affairs and has a period of time in which to investigate the financial circumstances of the debtor. They then will take a proposal put forward by the debtor and write a report comparing the outcomes from the proposal that's put forward to the outcomes that might be achieved if the debtor was forced into bankruptcy, and then makes a recommendation to creditors on whether or not it is in the interest of creditors financially for them to insist on the bankruptcy or to accept the compromise arrangement. If creditors accept, then the debtor is able to avoid bankruptcy, and the trustee or controlling trustee becomes the trustee of the personal insolvency agreement. It becomes their job to take control of those assets that have been pledged for the benefit of creditors, convert them to cash, and then distribute them as a dividend in accordance with the priorities that have been set and agreed. This all seems like it would be a great idea, but there is only a very small number of personal insolvency agreements that are successful in Australia, and in some periods there's been virtually none. The reason for this is, in my opinion, and largely supported by the evidence, that there is an inherent distrust amongst creditors and amongst the Australian population of personal insolvency agreements. We seem to accept that a person that may need to go into bankruptcy needs to actually enter bankruptcy, as it is somewhat of a punishment for that person for having found themselves in financial circumstances, sometimes through their own fault and sometimes through no fault of their own, and that bankruptcy serves that punishment or deterrent factor in ensuring that people will try and prevent themselves from incurring debts that they cannot pay. A controlling trusteeship is a period, generally speaking, of 2 to 3 weeks. That's not a lot of time for a controlling trustee to be given all of the information about a debtor's affairs, which can sometimes be incredibly complicated, digest all of that information, make an informed analysis of the outcomes for creditors, compare that with the outcomes in a proposal, report to creditors, call a meeting, and seek a resolution of creditors one way or the other. It's a very tight time frame, and it's intended to be, because it's not supposed to be that it prevents creditors from pursuing their legitimate rights in bankruptcy. So, a lot of creditors, including financial institutions, have policies that say that they will not support personal insolvency agreements, even in circumstances where the personal insolvency agreement is to their own financial benefit as opposed to bankruptcy, because they believe that it does not, to do so would be provide an incentive to debtors to incur debts that they don't be able to pay and then seek release through a personal insolvency agreement. This attitude is also very common at the ATO. The ATO has the view that they don't wish to incentivise people from incurring and not paying their taxes and then seeking to avoid payment of those taxes through a workout arrangement in a personal insolvency agreement. Most commercial creditors and the tax office have a minimum amount that they will accept as a dividend rate before they'll be willing to vote in support of a personal insolvency agreement. But that amount is always unclear and different from every creditor. So it's hard to know whether or not your personal insolvency agreement proposal will be considered favourably by the creditors. And that's some advice that you need to get individually, taking into account the full extent of your creditors, the full value of those creditors. For a personal insolvency agreement to be approved, it needs the support of 50% of the participating creditors by number and 75% of the participating creditors by value. And it needs both. There is no casting vote like in a voluntary administration deed of company arrangement situation. The controlling trustee requires both support by number and value, and by a higher value, that's 75%. So personal insolvency agreements are certainly harder to achieve than a deed of company arrangement is in a corporate insolvency context. So what are the risks for a debtor associated in seeking the appointment of a controlling trustee to get a personal insolvency agreement off the ground? Once you've appointed a controlling trustee, you must surrender your control of any companies. You cannot be a director of a company when a controlling trustee is appointed, in the same way as you can't be a director once you're bankrupt. So there can be significant disruptions to businesses or companies if you're the director of it and you need to consider a personal insolvency agreement. But I don't think this is a really big issue in the overall scheme of things, considering you will not be able to be a director of a company if you're ultimately made bankrupt. This is a manageable, or maybe perhaps an inevitable, risk that needs to be dealt with if you're facing the prospects of bankruptcy. Secondly, because of the very tight time frame of a controlling trusteeship, there are significant costs associated with putting forward a personal insolvency agreement. The minimum amount you would expect to be in the realm of maybe $25,000. And if the controlling trusteeship does not result successfully in achieving the execution of a personal insolvency agreement, then those funds have actually been foregone. So there is a risk that you will attempt to get a personal insolvency agreement up to avoid bankruptcy, be unsuccessful, but you will still need to come up with the funds associated to fund that process. And lastly, it seems that creditors have non-financial incentives for the way that they make decisions about personal insolvency agreements. This idea that a debtor needs to be held accountable and that they're somehow punished by being made bankrupt, and that there needs to be this element in place, means that creditors don't always act in their own financial interests, and it can be hard to work out which creditors will and will not support a personal insolvency agreement. All that being said, personal insolvency agreements have started to become a larger part of the Australian insolvency landscape over the last 12 months, driven by the increased numbers of personal insolvencies, largely driven by the high numbers of director penalty notices issued by the tax office, and the high numbers of personal guarantees provided by directors to creditors to secure supply and finance for their companies. Once again, we find ourselves with people who have significant things to lose from bankruptcy, such as control of their companies and businesses, needing to explore ways to avoid bankruptcy, and it being in their interest to do so, because if they do become bankrupt, their earning capacity will be significantly reduced by their inability to act as company directors. The last thing to really consider, and if you are wanting to put forward a personal insolvency agreement, is to approach the process in good faith. Regulators have recently let it be known that personal insolvency agreements that constitute a breach of duty or abuse of process will not be tolerated, and ASA has successfully applied to the court to have personal insolvency agreements that were set aside that were deemed to be an abusive process. Things that are considered to be an abusive process are when a debtor specifically incurs debts for the purpose of having them vote in the personal insolvency process, where a dividend is so nominal as to be virtually meaningless to creditors, and where the process is controlled by related party creditors and genuine arm's length creditors' interests or intentions are overruled by those related parties. For the best way for us to determine whether you have good prospects of getting a personal insolvency agreement approved, give us a call. We're happy to spend some time looking at your matter, your circumstances and your creditors, and giving you some realistic advice about whether or not you have good prospects of having a personal insolvency agreement approved. Until recently, personal insolvency agreements have all but faded away as being part of the Australian insolvency landscape. But in the last 12 months, Brian Palmer, we've had 5 different personal insolvency agreements approved for amounts roughly in the realm of between 10 and 15 cents in the dollar. These are people who have received director penalty notices, who had some equity in their homes that they could draw down and finance, such that would have been available in bankruptcy anyway, but this is far more certain and usually on better terms. They also offered to put some future funding in from their income and had received loans from third parties to help put together a personal insolvency agreement fund. That's 5 people who have avoided bankruptcy but also provided a far better return to their creditors than would have been achieved if they'd gone into bankruptcy, taking into account the costs of administering the bankrupt estate and the significant delays in administering an estate and dealing with all the legalities. In one particular case, creditors determined that the fact was that funds would be available now. Even though it might be slightly smaller than the highest possible estimate that a bankruptcy would achieve, that bankruptcy was expected to run for 3 years. A slightly smaller return was considered favourable by the debtor's creditors if it meant that with payment within a couple of months. These sorts of arrangements are capable of being put through. Creditors are looking at these more rationally, and they are a viable way to avoid bankruptcy. So if this is you and you think you need to avoid bankruptcy and you think you have the capacity to put forward a viable offer for consideration by your creditors, give us a call and we'll let you know if, in our opinion, it's got prospects of success. Stay tuned next week. We'll be talking about what happens if bankruptcy is unavoidable, but you want to try and get out of bankruptcy without having to serve a full 3-year term. The annulment process is not dissimilar to the controlling trusteeship personal insolvency agreement sort of arrangements that we've discussed today, but is far more successful. And we'll talk about the reasons why next week and some of the interesting circumstances that have played out where personal insolvency agreements have not been accepted, but bankruptcy annulments have. Stay tuned.